Welcome to the first meeting of the House Judiciary Committee. We do have a quorum. Mr. Clerk, please call the roll.
Representative Banta,
Present.
Representative Bauman,
Present.
Representative Blanton, Representative Burke,
Here.
Representative Dietz, Representative Flannery,
Here.
Representative Griffey,
Here.
Representative Colcarney, Representative Lewis,
Here.
Representative Maddox, Representative Mosier,
Here.
Okay.
Representative Nemus,
Here.
Representative Petrie,
Here.
Representative Roberts,
Here.
Representative Stevenson, Representative Whitaker,
Here.
Representative Williams, Representative Wilson, Vice Chair Decker,
Present.
Chair Elliott.
I'm here. So, good morning again, everyone. Thank you for being here. I would like to announce that the committee rules have not been sent out, but we do have those. They should be sent out later today, and we'll be operating under the same rules as we have since I've been chairman. I do want to take a moment of personal privilege to introduce my district judge, the Honorable Patrick Brasati, who is district judge in Boyle and Mercer counties. Thank you for being here today, Judge Barsati, and if everyone would make him feel welcome, I appreciate that. And I also see members of the Boyle County Fiscal Court here. I see Judge Trilly Bottom, and I see Magistrate Jamie Gay, and I see Magistrate Tom Ellis, and I see Magistrate Steve Sleeper, and I see Magistrate Paula Bodner. Thank you so much for being here, and if everyone would make them feel welcome, I think. And I also want to recognize the new members of the committee. We have Representative Jared Bauman, Representative T.J. Roberts, Representative Wade Williams, and Representative Mitch Whitaker. And so welcome to the committee, and we look forward to your work, and we know you're going to enjoy your time here. So thank you for being on the committee. We have two bills for consideration today, and the first one that we will take up is House Bill 38. Representative Tipton is the sponsor, and if he would make his way to the table and introduce himself and any guests that he has, and then we will proceed. There is a substitute as well. Representative Tipton.
Thank you, Mr. Chairman. I am James Tipton, House District 53, and I have a constituent with me today, Ms. Mary Ann Pratt. You ready to proceed, Mr. Chair?
Yes, you can proceed, please. Is your microphone on?
Yes, it is.
Okay,
I'll get it here a little bit closer. I have the same issue sometimes with members at the table, but Mary Ann contacted me back in June for the first time, and we've talked several times over the course of the last few months, and she shared an experience with me that she was going through that no one should have to experience. And no one should have to be worried about being constantly harassed. No one should have to live in fear of being physically harmed or possibly killed. And I haven't experienced that. But we started to work on House Bill 38. And Mr. Chair, as you mentioned, there is a committee sub on the bill.
There's a motion. Is there a second? All those in favor, please say aye. Aye. Those opposed, no. And the committee sub is adopted and before the committee.
And with the committee sub before us, the bill essentially, there's what it does. Currently, if there is a violation of an order of protection, it is a Class A misdemeanor. What this legislation does, on the third violation of an order of protection, as it's written on the same order, the same individual, that would move up to a Class D felony. I've talked to my county attorneys who are supportive of this. I've talked to my Commonwealth attorney. And I asked my Commonwealth attorney this question: do you have any other suggestions besides this to try to deal with this situation? He said, I really can't think of anyone. Now, none of us wants to increase our prison population. We understand the cost of jails and prisons, but there comes a point when we have to pass legislation that is here to protect the public. And I'll be happy to entertain any questions, but this time Mary Ann has some comments that she's prepared that she'd like to share with you about her experience.
Thank you.
Good morning. My name is Mary Ann Pratt, and I am a survivor of domestic violence. For a long time, I have lived in fear, feeling isolated and powerless. But today, I'm here not as a victim, but as someone who has reclaimed my strength and my voice. Sharing my story is not easy, as you can tell, sorry. But I do so with the hope of bringing awareness, offering support to others in similar situations, and proving that healing and freedom are possible. No one deserves to live in fear, and no one is alone. On the morning of December the 18th of 2022, I was awakened by my now ex-husband beating me. He was falling down on me, taking his elbow to my abdomen, to my chest, to everything. I pushed him off. I tried to get up. He took his right hand with his cell phone in it, swung around, and knocked me in the head, knocking me to the ground and almost knocking me out. I sat there dazed for a minute. He then laid his hand on the back of my head and told me if I tried to move or if I tried to say anything, he would kill me. So I sat there and I thought, I don't want to die. What am I going to do? After a little bit, I asked him if I could get up and sit beside him on the bed. He sat there motionless. He told me I could. I sat beside him, and then I realized there was a loaded gun beside him, and he sat motionless. He had no emotion. I slipped my feet into my flip-flops that were underneath the bed. I found my phone that was under my phone and slipped it into my pocket, and I thought, I have to leave. I have to run. I have to go. I started up. He tried to grab for me. I pushed him off, and I ran. I ran for the back door. Unfortunately, he caught me. He threw me up against the door frame, continued to hit me, tried to put his hands around my throat and choke me. I stuck my hands up, and I scratched him. I got out the door, and I ran. I ran down the road. I hid behind a truck, and I called 911. The police got there. They were able to finally get in the house, and they arrested him. He was taken to jail where I was given an emergency protective order until we could get to court on January the 10th. During that time, he was released from jail. He was placed on an ankle monitor, not supposed to be around me. We went for our DVO case. I was issued my domestic violence order for 3 years. Starting the next day, he began to break the DVO. Within 5 days, he had already called or texted me 23 plus times. And on Tuesday, the 17th, he showed up at my house at 2 a.m. in the morning, trying to get in every one of my doors, only for me to find out that he had sat outside of my house for over 2 hours with his ankle monitor on, watching for me to come outside. The cops showed up and they arrested him. He went to jail. He was found guilty of a probation violation, and he was found guilty of the assault on me and the domestic violence order violations. Unfortunately, those violations were all lumped into one. And all that can do is carry 12 months. When he was found guilty, he was issued 90 days for the assault on me, and then 90 days of home incarceration when he would be released. On August the 18th was when his probation violation was up, and he was to start serving the 90 days for the assault. The Shelby County Jail decided he was a good inmate. He served 3 days of the 90 days he was given for me, and he was released home on home incarceration. Within 6 days, he had started breaking the emergency protective order by making false accounts and fake profiles and following me on Facebook, Instagram, TikTok. I found them. I contacted the Lawrenceburg Police Department. They issued a warrant. He was rearrested. That was on the 21st of August of 2023. He was found guilty of his probation violation again. He was found guilty of 2 contempt of court charges. All of that time was to take him to March the 29th of this year. During that time, he sent me a 3-page letter from jail because they let him. He tried to call me from the jail, and my number had to be blocked. And on December the 30th, the Franklin County Jail decided he was a good inmate, and he was released. Within 2 weeks, he's broke the DVO again. He created a fake account under his mother's name, has reached out, liked different posts. We are now have 2 court cases coming up, one in family court and one in criminal court, because he decided to take to Facebook, tag me on videos, and at the same time make a statement. And I'm sorry, I'm going to tell you what the statement said, and excuse my language, that he would kill me to the point that if I was reincarnated, I would come back as a fucking abortion. He was given bond. He's out on bond for $5,000. He's on home incarceration. But when does it stop? When do I get to actually sleep? And when will my voice and everyone else's voice be heard? So that's why I've reached out to Representative Tipton. That's why I came today. I want to just show that I'm a person, and no one should live in fear every day. I have locks on my doors. I have alarms on my windows. I have multiple cameras up. And I know there's a lot of people here today for gun safety. I carry a gun. Never thought I would be that person. But it's the only way I can see to save myself if I have to. So I'm just asking that, this bill gets approved and you understand where I'm coming from and where other victims have to go through.
There's a motion and a second. There is some discussion. Representative Decker, and then I'll recognize Representative Stevenson.
Thank you, Mr. Chairman, and thank you for Bill's sponsor, and especially thank you. I operate a homeless shelter for women and children, most of whom are abused. Your story is not uncommon. In fact, it's common. Mm-hmm. And by you coming forward, you are speaking for so many women who don't have the courage, or they're afraid. They think that puts shame upon them. It actually is shame upon your ex-husband. And I support this bill thoroughly, and I thank you for being willing to come and talk about it so openly, because you give a face and a voice to so many women. Thank you.
Thank you.
Representative Stevenson.
Thank you, Chairman. A comment and then a question?
Yes, I should say Leader Stevenson.
My comment is, first, thank you for being so brave. And I want to welcome Moms Demand Action and the students that are in Mom Demand Action, because they actually believe the same things that you believe. Not that we should get rid of guns, but that the right people should have them. My question is, because I believe in this, I have a private practice that helps people. Does this include the social media posts and things that he, not just the physical contact, but any contact whatsoever with you, to include social media?
Thank you for that question, Representative Stevens. I believe if you look on page 1 of the committee sub, down under 4B, and then there's sections A, B, and B, it would be a Class D felony if it involves the attempted use of physical force or the threat of physical harm. That was some language that we had some constituent groups that reached out. And the reason I wanted to clarify this is sometimes the perpetrator, will have a protective order put out against the victim in reverse. And they were concerned that the actual victims might inadvertently get caught up in that situation. So that was the reason this was requested to be added into the proposed bill draft.
Okay, thank you.
Thank you, Representative Burke.
Thank you, Mr. Chair. Thank you, Representative Tipton, for bringing this bill. And thank you for coming to put a face to what is, as Representative Decker said, an all too common issue here in the Commonwealth. I want to say I'm fully supportive of this bill. My only question relates to the change in the House substitute relating to the fact that the victim has to be the same. I want to elucidate a little bit. I practice in the area of domestic violence. I represent a lot of survivors, and I see the same perpetrators come back to court with different petitioners, we'll call them. Typically, it's different women who have landed in a relationship with the same abuser, not knowing his history. And so my worry is with this change, it creates a potential for one man to victimize multiple partners and to harass and abuse them twice apiece before he ever finally gets the adequate punishment he needs to realize how serious this conduct is. Can you explain to me why this needs to be included in order for us to move forward?
Thank you for addressing that issue, Representative Burke. Of course, you know the original bill did not include this specific issue. It would include any order of protection. I can't make a committee sub because I'm not a member of this committee. But and Chair Elliott may want to comment on this. I think there were some concerns issued about that maybe it needs to be that way. I will tell you that since Monday, I have been reached out. The Attorney General's office has reached out to me. They share the same concern that you have. Chair Elliott had this conversation in the Senate. This may not be the final version of the bill. The Senate may have an idea to change that, and it's my intent to have that conversation once we get it out of the House and get it over in the Senate.
Thank you for that answer, and I would be very eager to see that change be made so that we don't set up a situation where someone can continue to perpetrate against other members of the community.
Is Scott West here? He had signed up to speak on House Bill 38. You want to come forward, Scott? And if you would introduce yourself, you may proceed.
My name is Scott West. I'm formerly with the Department of Public Advocacy, but today I'm here on behalf of the Kentucky Association of Criminal Defense Lawyers. And I'll tell you, I have not seen a committee sub. But from what I've heard of it, it addresses a couple of my concerns, going from a second offense to a third offense, and it involving some accusation or allegation of violence. There does remain an issue that I am concerned about, and that is how you get to the third offense. The way the statute is written currently, it is a violation of a protective order that can be contempt, or it can be a criminal action. It just cannot be both. But it is possible to get a contempt finding or two contempt finding in family court. And then when the first violent thing happens, and when I say violent, fourth degree assault, I don't call those minor assaults. It may be minor as far as the actual physical damage, but the indignity that's suffered, nobody would say that is a minor assault. But what it would mean is that you could have two technical violations of an order. Perhaps you are beyond the 500-foot limit from someone. Perhaps you are contacting someone in a non-threatening way, but you have an order that says no contact, and you were just calling to, you're trying to get back together or what have you. I have had clients in the past who have had protective orders, and then there's what some people call the honeymoon phase, where they get back together, and they say, well, but she doesn't care anymore. I don't care. You have a protective order against you that she can't lift. Only a court can lift it. And you get technical violations where there's no harm. And now those two can be the two predicate contempts. And those occur in family court. And let me tell you something. Those of you who practice in family court, if I had a hat, I'd take it off to you. I've had one divorce in my life, and that was because the prosecutor said, I will drop the bigamy charge if you get your client divorced from one of her husbands. And I thought, how hard could it be? And that was my last divorce, almost 20 years ago. And so, but criminal defense is a specialty defense too. And while there's a lot of attorneys who do both, there's a lot of attorneys that will do one or the other, but not both. And you are talking about two possible contempt where there's not a criminal defense attorney, not a prosecutor. The other person on the other side represents a client. They're not the minister of justice that prosecutors are required to be. They don't have to do things that justice requires in the name of equity. They represent a flesh and blood person. So that's my concern, is that you can have two minor ones. As far as the testimony that we heard today that was very compelling, let me tell you that the issue there is a charging decision. The testimony that I heard, that's stalking, and it's felony stalking. 25 texts, showing up and watching the street, that's stalking behavior. And stalking behavior, when there is a protective order, is a Class D felony on the first offense. So I understand that there was probably a different charging decision than maybe I would have made if I were a prosecutor. But the problem is not that we don't have laws on the books that felonize the behavior when it needs to be felonized. You know, the problem is perhaps not using all the arrows that are already in the quiver. And lastly, if I could address the issue of the third offense, it's already in the assault statute that a third fourth-degree assault against a family member or domestic partner, the definition is as expansive as the definitions in the protective order statutes. A third one is already a felony under the assault statutes. And in those cases, using those, all three of them would be fourth-degree assaults, which again, they're not minor assaults. They're fourth-degree assaults. I thank you for this opportunity to speak on behalf of the criminal defense lawyers of Kentucky.
Well, I think those are all good points. Scott, or Mr. West, we appreciate that. Is there any other discussion? Representative Nemus.
Thank you, Mr.
Wanted
Chairman.
to be recognized.
Thank you, Mr. Chairman. I always want to thank Mr. West for coming. I do think, in Ms. Pratt's testimony, and Representative Tipton, thank you for bringing the bill. Ms. Pratt, thank you for your testimony. I don't know where I can't see you. There's a big poll here, but I hope you know how much we appreciate your heartfelt comments and your story, sharing it with us. With respect to Mr. West's comments, I do think it's covered under the bill, the major concern he has, because in lines 4 through 6 of the bill, and in lines on page 1, and in lines 4 through 6 on page 2, it does require notice and a criminal contempt hearing, so the alleged perpetrator is notified and can defend himself. And then it says once a criminal shall constitute contempt of court and a criminal offense. So I think it's protecting the interest of the rights of the alleged perpetrator if he hasn't done it. So I think that's covered, and I'm not too worried that it goes too far. So support the bill, and thank you for the amendment.
Representative Wilson.
Thank you. And I would just add, and Mr. West said he didn't have the committee sub, but it seems the word convicted has been added under the committee sub that was not in the original draft. It may be a question to address as we're working on it. If there is just a contempt charge brought with the judge, does that count as first and second? And that may just be a question to add. I'm not saying one answer or the other. I'm just saying that may be something to consider and make sure that the legislation reflects the intention of the sponsor. Thank you.
So there's a motion and a second. Please call the roll.
Representative Banta.
Yes.
Representative Baumann.
Yes.
Representative Blanton,
Aye.
Representative Burke,
Yes.
Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Flannery.
I'd like to explain my yes vote.
Yes, please.
Appreciate the intent of this bill. I guess my concern and criticism would be that, as has been stated, this is already covered by, in my opinion, by first-degree stalking. I really like Representative Wilson's idea. I think maybe we could address this issue better by giving perhaps the court additional ability for some sort of contempt action when you have maybe kind of a pattern of violating orders. That might be a better way of dealing with the scenario that this victim has faced. But as far as any violation of a court order, I think that's already covered by first-degree stalking. I will vote yes.
Representative Griffey,
Yes.
Representative Kulkarni,
Yes.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie,
May I explain my vote?
Yes.
My vote in committee is yes, but there are a few things I think can be modified, and I'll discuss it with the sponsors. Stopped by a few times this morning. You were not available, and look forward to talking to you. Thank you, Mr. Chair. It's a yes.
Representative Roberts,
Yes.
Representative Stevenson,
May I explain my vote?
Yes, you may.
I'm voting yes. And what we know is that these beatings happen a long time before the woman even steps forward. So whatever rules we have on the books are not working. And this one doesn't take away from the stalking. It just adds under this provision for protective orders of protection. It reinforces these people need help and the system has to respond. Yes.
Representative Whitaker,
Yes.
Representative Williams, Representative Wilson,
May I briefly explain my vote? You can recognize. I'm a yes, and I'd like to let you know I'm more than happy to help if you need it or want my opinion on anything. A couple of the points that brought up, the third offense does have to be a use of force, and I appreciate that. I think that may alleviate some of the overlap between technical violations and force or violence. There will still be overlap between contempt and misdemeanor charges. That may be something we have to address. I'm not familiar with the first-degree stalking, so I won't speak on that. However, a third offense, assault, that requires 3 different acts of violence, where a violation may not do so. It's just simply reaching out or violating in some way. So, yes, great work, and I'd be happy to help if needed.
Chair Elliott,
Aye. So with 19 yes votes, 0 no votes, and 0 pass votes, House Bill 38 is amended by the committee substitute, is passed, and will be reported with favorable expression that the same should pass. Congratulations, Representative
Thank you,
Tipton.
Mr.
Thank
Chair,
you for
and
coming
members
to
of the committee.
share your story.
On behalf of myself and Ms. Pratt, we certainly appreciate your support, and we look forward to working with the members on how we can make this better.
You're very welcome. You're very welcome. Earlier, I failed to recognize, I saw the Boyle County Administrator, Julie Wagner, here, and I was looking right at her and didn't even introduce her, so I apologize, but welcome. It's good to see you. And I'm also going to recognize Vice Chair Decker for some guests that she has.
I just looked out and saw that we have 2 magistrates from Shelby County here, John Swindler and Jean Witt, and I want you all to make them feel welcome. Thank you. Welcome. Thank you.
Thank you for being here. And so our next item is House Bill 206, an act relating to wrongful conviction compensation. And Representative Nemus, who is the House Majority Whip, is the sponsor. And if you would come forward with your guests and introduce yourselves, and then you can proceed.
Thank you, Mr. Chairman. As we're getting situated. One more mic down here. We'll go ahead and introduce ourselves. My name is Jason Nemes. I'm a state representative from Jefferson, Oldham, and Shelby counties. We'll start my far left and go to the right.
Innocence Project. Suzanne Hopp, Kentucky Innocence Project.
Paul Hurd, Exoneree, Jefferson County.
Jonetta Carr, Exoneree.
Mike Von Allman, wrongfully convicted citizen of Jefferson County.
Good morning. I'm Winnie Yee. I'm with the Innocence Project.
And before you start, Representative Nemes, I think we've done this once before.
We have, Mr.
in this
Chairman.
committee.
Thank you. So we won't go too long.
There's a motion on the sub. Is there a second? There's a second. All those in favor, please say aye.
Aye.
And those opposed, no. And the sub is adopted. You have the floor.
Thank you, Mr. Chairman. This is a wrongful conviction compensation bill. I call it the there but for the grace of God go I bill. We're going to have some of our exonerees speak, but as we're listening to these stories, let's not try to listen and say pity on those folks. I would like for us, each of us, to put ourselves or our loved ones in their position, because as they sit here today, they are just as innocent of the crime for which they were convicted and served as each one of us are. So as they say their stories, let's put ourselves and our loved ones in their positions. We'll start with Paul.
Thank you so much for allowing me to speak, members of the committee. I spent 20 years wrongfully convicted in Jefferson County. I was released 5 years ago. I would like to talk about my support for this bill, how when I was released, housing was difficult, and I was fortunate enough to have family members still living. A lot of exonerees do not have that luxury of people to help them when they're released, and we're not afforded very much as wrongfully convicted exonerees. So I really support this bill. It's overdue and necessary. I appreciate everyone's support of this bill.
Jonetta.
My name is Jonetta Carr. As of today, I'm the youngest person to be wrongly convicted in Kentucky history. My wrongful conviction started when I was 16 years old, taken into an interrogation room, left for 11 and a half hours without parental consent. When I walked into the interrogation room, I thought that if I just told the truth, I would get to go home, which is what I was told. I did tell the truth, that I was innocent. From there, I got booked into the Jefferson County Youth Detention Center, where I sat until I was 18, awaiting a trial that never happened. As soon as I turned 18, I got transferred to the adult jail. The whole time I had to sit there for this crime I didn't commit. I had to sit there and watch people come and go and use the jail as a revolving door every week while I continued to sit there. I ended up spending 4 years in jails and prisons and serving out 9.5 years on parole for a crime I did not commit or have anything to do with. Luckily, by the time I was released, I still had family members that was alive, and I would like to shout out to my mom because she's been my support and my strength every day. When I went to go fill out job applications and they said, no, we cannot hire you because your charges, because this record still follows me, I would cry to her and she would be there, and because her and God, I have the strength to stand here before you today. Wrongful conviction is something that I will live with for the rest of my life, but I am not a victim. I just find it appalling that as a person who had to go to prison and serve time and get treated like a criminal for a crime that I did not commit, that people that are actually guilty of crimes get more resources than we do. I have met exonerees in Kentucky. I'm very close to all of them. Some of them have spent 20 years, 15 years in prisons and jails for crimes they didn't commit. Some of them are still not here because they have passed away and have never got a chance to see any type of relief from the injustice that they face in Kentucky. I would just like to tell you all thank you, and I support this bill.
If you want to. My name is Mike Von Allman. I was wrongfully convicted in 1983, and I was exonerated in 2010 when the Kentucky Innocence Project uncovered this incredible case of mistaken identity. When we look at wrongful conviction at face value, we see there is nothing partisan about this issue. We universally agree that confining someone for years over a mistake is wrong. and then to open the doors and let them go free only is wrong as well. This bill addresses that wrong. By no means will any of us testify that it makes our wrongful conviction right. We'll just agree that it's a fair way of addressing the wrong. I urge all of you to support this bill. Thank you.
Thank you, Mr. Chairman. I'll go into some of the provisions, and then Susan or Winnie may have some comments, and then we'll be happy to take any questions. This is the most important thing to know about this bill is you have to prove actual innocence. This is not just the constable has blundered, or reversal of a conviction, or even a pardon. That's not enough. You have to prove that you're actually innocent of the crime for which you were convicted and served time. There's a 2-year statute of limitation to get into some of the nuts and bolts. There's a 2-year statute of limitation, so you have to bring it within 2 years. It's $65,000 every year for you were in custody, $32,500 that you were on parole or on the sex offender wrongfully on the sexual offender registry. There's reimbursement for restitution costs that you had to pay, things of that nature, to kind of put them whole, what the things that they wouldn't have had to pay had they not went through this process. There is a tuition waiver so they can get back on their feet, hopefully go to school, get educated. A number of them, like Johnetta, so young when they were convicted. That's something that we thought was appropriate. Reentry services by the Department of Corrections. And another thing I wanted to note, there's other things in the bill, we've talked about it before, is if you do have a 1983 claim because maybe something was wrongfully done, then you can't have a double recovery. You can only get one recovery. And so there's either an offset, or you have to pay some money back that you would have if you received money under this and then filed a lawsuit. So there's that to make sure that there's no double recoveries. I do want to thank Representative Dietz in particular for helping on the family aspects of this, and Representative Petrie for helping on a number of the nuts and bolts and other things of this bill. The Innocence Project of Kentucky has done wonderful things across the Commonwealth for a long time, and this is another bill that they've worked on. I want to thank them for helping here.
Motion on the bill.
There's a motion and a second. You can continue, Representative Demas.
That's all I have, Mr. Chairman.
Well, thank you for bringing the bill. I'm a co-sponsor, so you've convinced me of the propriety of the bill, and I want to say to each of you what a nightmare you've had to go through that unfortunately was reality for you. And $65,000 a year for each year that you were wrongfully imprisoned really isn't that much money when you think about your life being totally taken away for you for that period of time. So you have my appreciation for coming before the committee, sharing your story, and I always have to ask, where's Barry Scheck, who obviously has founded the Innocence Project across the country. So appreciate the work that you do, because I know you've made a difference here in this room. So, and if you have any comments from the Innocence Project, I'll allow those.
Thank you for hearing us today. This bill is long overdue. I personally have seen exonerees who have walked out of prison in their late 60s after being in for 20 or 25 years. I don't know if anybody can understand the impact that prison really has on you when you've been in there for several decades. But the reality of their life is they're walking out with no job skills, no home, family members that may have been deceased, their aunts, uncles, fathers, mothers, the people who cared for them, that might have an eye out for them now. They actually, if they're still around, they need their help. They need, and they can't help them. The picture that I want to paint in your mind's eye is one of our exonerees that we walked out several years ago that came out of prison in his late 60s, and he had a trash bag in each hand. It was everything he owned. No family that he could return to. We located a cousin that was in Florida, and fortunately that cousin was able to come up and help. But for several days, the Innocence Project put him up in a hotel, fed him, got him a cell phone so that he could contact those family members that were still around. So this idea that somebody has nothing, they walk out with nothing. And then if there is a civil remedy, if there is a civil recovery to be had, that often takes 5 to 7 years. And so I can think of several exonerees that have passed on. They were never able to see their civil suit to the very end. This small amount of money, compared to what the wrong that has been a part of our exonerees' lives, would allow them to get back on their feet, put a roof over their heads, get a car, and even become possibly productive members of society in that period of time, because this would be a much more expedited and streamlined type of process that any kind of civil recovery might allow. Thank you.
Thank you. And you're recognized.
Thank you. I'm Winnie Yee. I'm with the Innocence Project. We work across the country to exonerate the innocent, and we support policies that prevent, reveal, and address wrongful convictions. I'm really grateful to our 3 exonerees who are here today. They are one of 22 individuals in the Commonwealth who have been wrongfully convicted since we've been calculating that since 1989, and collectively they've lost over 200 years of their life to a wrongful conviction. Wrongful convictions are a grave injustice. They're a symptom of our broken criminal legal system, and one way that we can try to address this is by promoting this bill today. When exonerees are released from prison, they are often released without any support. As you heard, not only is it the nightmare of the wrongful conviction, but it's the nightmare doesn't end at that point. They are still struggling to get back on their feet, to secure housing and jobs in the face of discrimination. And the state really does have a responsibility to try to render restitution when possible. I'd also like to note that 38 states and the District of Columbia and the federal government have all enacted financially sound compensation laws that create frameworks for people to apply and to receive compensation once their claim is reviewed by a judge. And this is what this bill is doing today. We hope that the Commonwealth can join those 38 states. Thank you.
Thank you, Mr. Chairman.
I think Mike wanted to make a comment. I saw when I was going through my long-winded address, I noticed you may have wanted to say something.
I appreciate the attention you've given me to that, but it was part of a moment that I had a moment ago, and sorry it's gone.
Sure, I understand. Representative Kulkarni.
Thank you, Mr. Chair. Thank you to the Innocence Project for the work that you all do. Thank you, Representative Nemes, for bringing this bill. And thanks to each of you for being here, for your courage and your resilience in testifying before us today. I just had a quick question, Representative Nemes, if you don't mind just kind of going through very briefly what is the difference in the committee sub in the original bill.
Thank you. So largely it's technical changes. There's a couple changes we've taken out. We've clarified some stuff on child support with Representative Dee's help there to get the language right. I don't practice in that area of law. We have made sure that it was a conviction in Kentucky. We have limited the attorney's fees, so if you go over $25,000, then it's limited to the contract rate, the normal contract rate, which I think right now is $150 an hour for attorney's fees. We made sure we use the correct CPI, and we've also removed provisions that would have provided for housing, for health care, and required reimbursements for financial education. So that we've removed those provisions. That's what the difference is between the committees up.
Thank you.
Largely, it tightens up things to make sure that it's Kentucky specific and so forth.
Representative Flannery.
I have some comments and a couple questions, please.
Yes, go ahead.
I guess starting off with some comments, I think it's really important that when we recognize that there have been mistakes in our justice system, when we don't have a perfect system, it's a very good system. I wouldn't call it broken, but when we realize that something has happened that shouldn't have happened, we need to correct that. And, when it's equally important that we do justice, so when people are guilty that of very serious crimes, that we do everything to make sure they are punished. But when we have people that truly are innocent and the government has punished them and convicted them, that we recognize that error and try to do the right thing, and that is why I support this bill. I guess a couple questions that I have. And I've talked to Representative Nemes about this. It appears that the burden of proof is still preponderance. I guess maybe kind of a question or your thoughts. Would it perhaps be better to have a higher standard of clear and convincing, given the gravity of what we're dealing with? Because one of the things that I really like about this bill is you actually have to show that you're innocent. It's not just, well, he or she, probably didn't do it. You have to actually show that you didn't do it. And given the gravity of what we're talking about, I think it might be better to have a higher burden of proof of clear and convincing. So thoughts on that?
Yeah, as you noted, this bill creates a universal framework and that the claimant does have to provide affirmative proof of their innocence. The standard is preponderance of evidence, and that is the standard that 14 other states across the country do file, including Idaho, Indiana, and Kansas. We can really name of no instance where the preponderance standard, awarded compensation to someone and that an error has been made. And I think it's important to note that when the court does vacate a wrongful conviction, it has at that time already examined all of the facts and found that the original conviction was unsustainable. We have found that in a couple of states that have enacted laws where the standard was clear and convincing, they are now going back to change that standard to preponderance because they found that the law was not working as intended and that it was not being effectively implemented. And so we believe that the current standard is most appropriate and fair.
Most civil cases, I know there are different standards with civil cases, but most civil cases have the preponderance standard. That's what was brought to me. I also looked at Indiana. I'm an Indiana lawyer as well as Kentucky, and I think that's the fair way to go forward. I understand the argument. This is the first step of the process. I don't want to change it, but I understand the argument going forward, and we can have that discussion further.
All right, second question. Any estimates on how many persons that this would actually apply to? So how many people have been are innocent and could potentially be eligible if this were to become law?
Yes, we've examined the different cases where there have been no civil suits, so that where there's been no monetary award. And we believe that the realistic estimate for the immediate impact is going to be about $3 million. It could be potentially a little bit higher, but the majority of individuals that might be able to make a claim under this law, some of them have received compensation already. Some of them have left Kentucky and probably will not even be aware of this statute. So we think the most realistic estimate is $3 million, but that's an immediate hit. That's looking at all the cases in the past, in the rearview mirror. If we were to look forward, the Innocence Project gets approximately, on average, 1.2 exonerations per year. And so on average, those individuals are in prison for about 15 years. So you would have possibly one claimant per year at somewhere between $650,000, maybe $900,000. That would be the estimate going forward. So it's a really very minimal impact.
Right, and Representative Flannery, my understanding is it's between 12 and 20 people, but a number of those have received compensation, just to make sure the non-lawyers, because there's some non-lawyers on our committee, just to make sure we're all singing from the same 8 bar here. If there's been something wrongfully done and not just the wrongful conviction, you can file something like a 1983 claim to say that your constitutional rights have been violated, but if you do that, that's showing that there was actually negligence or intentional misconduct, then you can recover. But for the people who it was just a mistake, they can't recover. We're really trying to get after that group. So about 12 to 20 people. And I will note that $3 million, which is our estimate of the upfront hit, that will be paid out over 3 years, not a lump sum under the bill. So anybody who gets a compensation, can show that they're actually innocent now or in the future, it would be that kind of a payout.
And just to understand the answer, is that 1.2 persons on average nationally or just in Kentucky?
That's Kentucky's estimate.
Okay, thank you.
Thank you. So following back with what Representative Flannery was discussing, the evidentiary standard is clear and convincing evidence in the majority of these states that have this law. Is that correct?
Preponderance.
Or a plurality?
I will get the count to the committee.
I didn't do too well in statistics.
I'll get the exact count
right?
to the committee.
Yeah. Okay, well, thank you. Representative Whitaker, you're recognized for the first time on the committee.
Thank you, Mr. Chairman. I just wanted to draw attention to one of my favorite parts of this bill, Mr. Nemus. In this bill, a person that is found to be wrongfully convicted receives a tuition waiver for up to 120 credit hours and waiver of mandatory fees associated with attendance at any public post-secondary educational institution in Kentucky. That is phenomenal. I just wanted to see if I could get some testimony on how impactful that will be for the wrongfully convicted in our state.
Comment on that?
It would be very, very impactful for me. Before I got wrongfully convicted, I actually had dreams of being a paralegal. So I was in Sullivan University pre-law. Well, obviously, as y'all know, life happens. I got out. I was trying to make up for lost time for a little while. Let me tell you, that's something you just can't do, okay? So I ended up becoming a mother, and I've been back and forth, with college while trying to work and be a mother, and I do plan on going back to finish that. So that would be very beneficial to me. Thank you.
Chairman, if I could also answer that a little bit indirectly. It was, Susan noted earlier, one of the portions of this bill, one of the purposes of this bill is to get people back on their feet, make them contributing citizens, and that's all great. But I want to say this. If there's anybody in Kentucky that has the right to be bitter, I mean, my goodness, it's the people that are beside me and others who I've met. These are the best people I've ever met. They are not bitter. They believe in the things that we believe in the system. And man, I just want to say how blessed I am to know them. So they're already, even though we're trying to get them back on their feet fully, they're already massively important to our Commonwealth, that they exist and that they're doing the things that they do. They're some of the best people I've met. And if I were them, man, I would be so bitter, and they're just not.
So we have 5 minutes left, and I'm going to recognize Representative Roberts, and he'll be our last.
So I just want to offer some commentary. Thank you, Mr. Chairman. I want to offer some commentary on why I support this bill, because there have been remarkable incidents of false accusations, predatory plea bargaining that has led to innocent people spending time in prison. And they are absolutely entitled to compensation, and they're entitled to accountability. And this is a measure to guarantee accountability on our end as a government. Particularly, I think about Brian Banks. He was a 5-star linebacker recruit committed to USC, and then in 2002, all of that fell apart when he was falsely accused of rape. The cards were stacked against him. He was facing a life sentence, and his attorney urged him to take a plea bargain for 5 years in prison, 5 years probation, and lifetime registration as a sex offender, even though he did not do it. 10 years later, his accuser openly said that this was made up. There was no presumption of innocence for Brian Banks, and in many cases there's no presumption of innocence for several people. And when it comes down to it, those individuals are entitled to compensation, because these allegations are not just lies. They're weapons. They destroy families, they destroy careers, and in many cases they destroy lives. And even if they beat those charges, the process can be the punishment. So this is a crucial first step in ensuring accountability, where we're taking accountability as a government for the parts that's there. And I hope this bill is a first step in that essential conversation and ensuring that there is accountability for those who have wronged the innocent. Thank you, Mr. Chairman.
Thank you. Mr. Secretary, please call the roll.
Representative Banta?
Yes.
Representative Baumann?
Yes.
Representative Blanton?
Aye.
Representative Burke?
I'd like to explain my yes vote.
Yes, please.
I am disappointed that the House substitute doesn't allow people who have been wrongfully convicted to have a certificate of innocence. I think it would be really meaningful, just putting myself in your shoes, to have a piece of paper that I could set down in front of somebody and be like, and not only did I not do it, I am innocent. The court has found I'm innocent. I have no idea why we can't give that to you. So I would really like to see that fixed before it comes to the House for a vote. And I'm grateful for this bill, and I hope we can at least start to make things right for you. Thank you.
Representative Decker?
Yes.
Representative Dietz?
Yes.
Representative Flannery?
Yes.
Representative Griffey?
Yes.
Representative Colcarney?
Yes.
Representative Lewis?
Yes.
Representative Maddox?
Mr. Chair, may I briefly explain my vote?
Sure, go ahead.
I'm voting yes today, and this issue has been so thoroughly vetted as far as I'm concerned. We have discussed this a multitude of times during the interim, and course, during the regular session. And I commit to not only voting yes here today, but doing everything that I can to get this bill moved beyond the committee, on the House floor, into the Senate. And I know the sponsor feels the same way. And I would just urge my colleagues here on Judiciary Committee, let's vote yes, but let's also really try hard to get this moved and get this passed into law so that we can do what's right here today. Thank you.
Representative Mosier,
An enthusiastic yes.
Representative Nemus,
Yes.
Representative Petrie,
May I explain my vote?
Yes, you may.
Thank you. It'll be a yes today in committee, and I want to make sure that I acknowledge the sponsors' work on the bill. If anybody's ever been through a serious tear down with me on a bill, he's gone through 2 of them plus. And
I'll take the
addressed-
plus.
and has worked well on the bill. It is a yes.
Representative Roberts,
Absolutely yes.
Representative Stevenson, Representative Whitaker,
Yes.
Representative Williams, Representative Wilson, Chair Elliott,
Aye. So with 19 yes votes, no votes, and no pass votes, House Bill 206 is amended by the committee, substitute is passed, and will be reported with favorable expression. So
Thank you, Mr. Chairman.
Congratulations, thank you.
Thank you.
And if there's no further business to come before the committee, we will stand adjourned.